morning everyone, and thanks for having me back. It's good to see you all again. I just thought I'd give you a quick update on what's been happening in ANCAT, and here he is. I've had to start without a joke, David.
I'll finish off with you.
So there's been two recent decisions in the ANCAT appeal panel which are helping us to define what is a major defect and what it takes to prove their existence. So the first of these cases is Vella and Mir, and that was decided just in late January of this year. So these proceedings were commenced by the Mirs on originally. They had purchased residential property from the Vellas. Cathane Constructions was the builder engaged by the Vellas for part of the works being complained of. The Mirs sought damages from the Vellas for breach of the statutory warranties under 18B of the Home Building Act. Experts for the Mirs was Mr. Zarkos, who many of you would be familiar with. The Vellas had Mr. Capaldi and Cathane had Mr. Matley. The experts went to a conclave as they're required to, and at the conclave and following the conclave there was disagreement between Mr. Capaldi and Mr. Matley on the one hand and Mr. Zarkos on the other hand as to whether there was any defects. Cathane accepted liability for one of the 7 defects, but otherwise attributed all other liability to the Vellas. So the tribunal found that the Vellas had to pay the Mirs $143,000 and Cathane would have paid the Mirs the sum of $3,000. The Vellas appealed to ANCAT and to the appeal panel. One of the grounds of the appeal focused on Section 18 of the Home Building Act regarding the limitation defence. So they argued that none of the items in dispute were actually major defects, which meant then that the proceedings had been commenced out of time, being commenced more than 2 years after the completion of the works. In making their decision, the appeal panel actually provided a really helpful sequence of their analysis that they have to go through when assessing a warranty claim. So first of all, the first thing they need to consider is when does the statutory warranty period start? As you would know, generally that is the date on which the work is completed, and the Act goes through the definition of when the works are actually completed. The next step then is to determine whether a statutory warranty has previously been enforced, and then if so, does 18E2 of the Act apply regarding other deficiencies? So that section provides that even though that they have made a previous claim, they can actually make a claim again if there are other deficiencies that are being claimed. The next step then, this is where you all come in, is to determine whether each of the claimed or each of the defects are in a major element of a building. So the Act generally defines a major element to be an internal or external load-bearing component of a building that is essential to the stability of the building or any part of it, or a fire safety system, or waterproofing, or any other element prescribed by the regs as a major element of the building. So if the defect then is in a major element of the building, the next step is determine whether it's actually a major defect. And that's defined by the Act as one that is likely, or that causes or likely to cause the inability to inhabit or use the building or part of the building for its intended purpose, or the destruction of the building or any part of the building, or a threat of collapse of the building or any part of the building, or otherwise be a defect prescribed by regs, or use as a major defect, or involve a product used in contravention of the Building Product Safety Act. So assuming you've ticked all those boxes, you then move on to the question of whether the application has been made within time by reference to when the statutory warranty period commenced, when it will expire, and then when the proceedings were commenced with the tribunal. So in analysing the defects in the Mirs and Vella case, the panel had made it clear that the expert evidence is relevant, obviously, to whether a claimed defect is a defect in a major element of a building, and then whether it is a major defect. But unlike what most people think, it's actually not determinative of the issue. So in its judgment, the panel noted that a significant problem with the homeowner's evidence was that the conclusions by the expert that a particular item was a major defect was not properly explained, and in particular, they didn't explain how it was a major element or what made it a major defect. So the tribunal then, the panel further noted that the tribunal had adopted the opinion of the applicant's expert in relation to whether the items were major defects without reference at all to the statutory definition, and in doing so fell into error. As a result, the appeal was allowed in part. Moving then to the next case, which is Ashton and Stevenson, which was only just decided a couple of weeks ago. It also dealt with the definition of a major defect under 18E of the Act. Again, that case highlighted the effect of the 2014 amendments requiring a major defect to be a serious problem which impacts upon the habitability and use of the building, and it's with potential destruction. So applying the analysis of Vella, the panel stressed that the consequences of a major defect must be shown in the evidence to have or to probably have a proven consequences for the habitation or use of the integrity of the building. Needs evidence to prove the existence of the major defect would need to show more than just an inconvenience and could not be satisfied by speculation or assumption. And evidence from the occupants or users of the building would be necessary to establish these major defects of the claim, rather than just expert evidence. So they need lay evidence from the homeowners as well as evidence from you guys. So following analysis from the panel in Ashton and Stevenson, they found a number of defects claimed in the case were actually not major defects. So one such example there was the issue with rainwater entry from a balcony floor. The issue was found to relate to a major to a major element, being waterproofing, but it was still not a major defect because evidence relating to the factors in 18E was scant. So it means that when a claimant or an applicant is asserting the existence of a major defect, it's important to adduce evidence on each of the elements identified in 18E4 of the Act, some of which are not matters for expert evidence. So the homeowner would actually need to be giving evidence themselves with respect to those elements identified in section 18E. Any questions?
What about the time limitations of that Villa case? Was it within the scope of the statutory time?
No, so if it was a major defect, so if it's a major defect, they've got 6 years. If it was a major defect, then they were within time. But because they were found to be other defects, being not major, then it means they only had a 2-year period, so they had commenced out of time. So that was the big issue there, where the homeowners were asserting they were in time, and the former homeowners were saying, no, they're not major defects, you're out of time, and then the appeal panel agreed with them. So just in terms of expert reports, Zarkos, in that Vella in Mears case, one of the issues was the cracking in the render. He had found the cracking in the render to be a major defect, and I've been in many a case where the cracking in the render has been a major defect. Others where it hasn't, depending on the extent of it. But just with respect to that aspect of his report, he had said whether or not, as under the heading major or minor defect, he had said, in my opinion, the front wall coating has become loose and should be considered a major defect, as the wall does not conform with this part of the BCA. That is the coating part of the building, and it has become unstable, and hence it's my opinion that it should be regarded as a major element. So that was the major element aspect, and then he went on to talk about whether it's a major defect. Further, the failure of the wall may cause or is likely to cause the inability to inhabit or use part of the building for its intended use, and there may be a threat of collapse of part of the building. So that originally was accepted by the tribunal as being a major defect, but on appeal, the panel went back and had a look at that and said, well, actually, it doesn't comply, it doesn't satisfy the elements of 18E4 of the Act. So where once that was found to be a major defect, the appeal panel said no, there's not enough evidence there, we need more with respect to those elements. So just a good thing to remember in writing your reports, that it won't all come down to you, it's going to be evidence from the homeowners generally as well. Thank you.
Morning all, thank you Sharon jumping in and doing a great presentation. Couple of small things this morning. Firstly, another case. Those of you who might follow our website, we've just recently published a short article about a Court of Appeal matter, which was about design defects and builders' liability for design defects. And what happened in that case was that the developers got an architect. The architect obviously did the design and produced plans and specifications. Turned out that the design itself was defective, didn't comply with the code, didn't comply with various aspects of the development consent. The builder went ahead and built, and there was no issue in the case that the builder had failed to build in accordance with the plans and specifications. The builder had in fact built in accordance with the plans and specifications. Nonetheless, the subsequent owner, the Owners Corporation, was successful against the builder because although, of course, the warranty that the builder will build in accordance with the plans and specifications hadn't been breached, nonetheless, what was built wasn't in accordance with the Act and other laws. Now, the builder said, well, but hang on, I've complied with one warranty, you can't stick me in with the other warranty. And the Court of Appeal said, no, we can. You have to comply with all the warranties. They aren't read together, they're read separately. And even if you comply with some of them, if you don't comply with one of the others, then you're still liable. Now, you will know, of course, that there is a defence under Section 18 for a builder, provided the builder has either identified in writing to the owner or the developer that what the builder is being asked to build will not comply, is not good and proper and won't comply with the laws, or that the builder has been directed in writing by someone on behalf of the developer to build in a particular way. But what it means is that contractors have to be very careful, and so far as you guys are concerned, when you are writing reports and talking about defects, remember that just because the builder has built in accordance with the plans and specifications, if they nonetheless breach the code, if what's built breaches the code and the design breaches the code, then there is still a defect. Of course, it'll be up to the court or the tribunal to determine whether or not the builder can establish the defence. If the builder's told the developer that there's going to be a problem if the builder builds in this way, that's not a matter for you guys. It's only a matter for you guys to identify whether there's a defect, which is either not in accordance with the plans and specifications, not fit for purpose, not built in a proper and working manner, in breach of a law, which could be the code, could be the development consent. So something to remember when you've been retained. Then, because I know you guys like to hear a little bit about the foibles of the legal profession. A matter I came across, disciplinary matter. They're very popular, lawyers being disciplined, because sometimes they do misbehave. I know you find it difficult to believe that, but they do sometimes. This came out of the disciplinary tribunal in the UK. A solicitor had been reported to the trust and disciplinary people because the client was concerned that he'd asked the solicitor for a statement of account in respect of funds he'd instructed the solicitor to distribute and hadn't received that account. Well, there was a quite extraordinary response from the solicitor, writing direct emails directly to the client and copying in the disciplinary people at the English equivalent of our law society. And these emails culminated with one written at 3 in the morning. You know, nothing good comes out on social media or elsewhere at 3 in the morning. Written at 3 in the morning, and he said he addressed this to the client, but copied in the tribunal people. You're the arse that triggers all of the complaints. You are sick. You need professional help. This is all in caps, by the way, all in caps. But unfortunately for all who come into your orbit, you are also a dishonest and disgusting piece of shite. But oops, I forgot. You are a manic depressive with mood swings and no real grasp of reality. So enjoy your world of insanity. You won't be surprised to know that the Law Society found that he'd breached professional obligations. And finally, but in his well, kind of defence, he didn't appear at the hearing, by the way. He said that he was deeply embarrassed by this and apologised, but he maintained that the disciplinary people were seemingly taking the side of a criminal money launderer. And he added, I certainly do not poke fun at people with mental illness, and I don't understand how that conclusion can have been drawn. So he got costs of £8,000 and fined £5,000. So contrary to popular belief, even lawyers don't